Hello, everybody. We're doing our podcast again, but we're actually doing it live during one of our monthly meetings because we got such a good question that I hear quite a bit, and I can see why it's a little confusing. So go ahead and ask the question, Maddie, that was presented.
All right. So the background for it is we sent the ADA accommodation letter to an employee who responded that their next doctor's appointment is not for another month. We are aware that the employee is being treated by multiple physicians. The questions are, how should we proceed in this case? Are we obligated to wait for the next scheduled appointment, or can we request medical documentation from one of the current treating providers sooner?
So I'm going to answer this question from the perspective of FEMLA and then the perspective of ADA. And the most important thing to start with, the employee, and you want to write this in all your letters, it's on all of ours. The employee is solely responsible at all times for providing medical certification, confirming the need for leave or an accommodation that meets the criteria of the organization, and the confirmation that they are meeting the eligibility for the regulation and the policy. So we start with that and we inform them of that. And then by regulation with FEMLA, they get 15 days. And it's 15 days. They don't get a month. They get 15 days. So what do? And we can bring up our USA Venn diagram, Maddie. You can bring up the membership site USA, but the system has never changed, everybody. We have a notification that tells them we need them because we or should have known they have a need for a FEMLA leave or a need for ADA accommodation. And by the way, there is no date requirement in ADA. So I give them 2 weeks, 15 days as a standard operating procedure. So there's no confusion that that's really all they should get is 15 days to respond, because it is the employee's sole responsibility at all times provide medical confirmation confirming the need for a FEMLA leave and the eligibility requirements, and confirming the need for an accommodation. The difference is we might temporarily accommodate under ADA, but FEMLA, yes, we're letting you be on leave, but you don't respond in 15 days and we can deny the leave. So the question was, they need a month. Okay, well, we can decide as a standard operating procedure when we implement the FEMLA that we're going to give everybody a month to get us a medical certificate. And that means everybody, every single person, no matter how much we like them or dislike them or how many times they tried to give it to us, we're going to give everybody a month. Do not suggest that. They have 15 days. So after 15 days under FEMLA, we will send a second request letter. Not required, by the way, but we do. Hey, employee, didn't know if you didn't realize you missed the date, but you're only eligible for FEMLA if you provide medical confirmation that indicates you meet the criteria. Doesn't matter what state you're in. Even in California, they still have to check that box that a doctor read all of the definitions of FEMLA and CFRA, and they check the box that they're eligible. They're eligible. That's what we're looking for. And we want to know how long, but under FEMLA, they don't have to tell us. They only get 12 weeks or 480 hours or whatever the calculated hours are, but they have to give us certification. So the second letter says, okay, you didn't get a certification. If you don't confirm for us in the next 7 days why you're eligible for FEMLA, we're going to deny you. But you might be eligible for ADA. So then we send that letter. And when they don't get it to us in another 7 days, we send a third letter. And this is my strategy. This is the LMS strategy that Maddie and I have developed and implemented over the last few years and over the last 10 years, and specifically with my clients over the last 30 years before I created it as a very clear process that has letters attached to it. So you're consistent and you do it exactly the same way every time. So you cannot discriminate because you're consistent and you do it the same way every time, which means under FEMLA, you get 15 days. And when FEMLA ends, everybody, look at the Venn diagram, ADA begins. And when FEMLA ends, we deny you the protection for your medical benefits. And the ADA letter says, by the way, I gave you 15 days to get me the FEMLA letter. You didn't. I gave you another week to get the FEMLA letter. You got 3 more days to get me the document, or I'm going to be moving you into denial under FEMLA. And you've got 2 weeks now to get me that really detailed ADA, how does your disability impact your ability to do your job letter? Everybody take a breath, because this is the system. And if you don't look at the big picture, like the Venn diagram shows you, it's FEMLA, then it's ADA. It can happen at the same time as workers' comp. It can happen at the same time as pregnancy disability leave under ADA. It can happen under ADA Accommodation Pregnancy Workers Fairness Act, that they just don't get you the medical certificate. And let's go into your daughter's baseball stadium at their high school and put in 6-point font all the different reasons why I can't get a medical certificate. And none of them matter. You have 15 days to get me medical certification confirming your eligibility for FEMLA leave, or under our leave management system. We give you a letter that says you've got 7 more days. Maybe you didn't understand. We can't protect you unless you give us medical confirmation you are eligible for this leave in compliance with our state regulation, including California. It's not hard. And then if you still don't do it, now we are transferring from FEMLA to and we're sending a letter that says, and these are all certified mail, confirmed delivery, Federal Express, and regular mail. One or the other, everybody. You got to do both. I mean, you got to always send regular mail and one of the other options, always, or you don't have confirmed delivery. And then you're saying, so we're cutting off your FEMLA, and you have 2 weeks. If you don't get us the confirmation of why you need protection under ADA, your medical benefits will end the first day of the month your unpaid leave begins. Very important little caveat that gets everybody's attention, especially if they're on a workers' comp leave. Now look at your Venn diagram. Workers' comp happens at the same time as FEMLA and ADA. So if you're one of the state or federal or county agencies or JPAs that are implementing these things separately, or you are really stuck on that workers' comp scope of control stuff, take a breath. Workers' comp doesn't protect your job. Workers' comp doesn't protect your medical benefits. FEMLA does both. When they don't reply to that FEMLA certificate, it is our job to be HR and take care of the company and cut off their medical benefits and remind them, sure, you need another 2 weeks to get us a certificate under ADA that tells us how your medical disability impacts your ability to do your job and come to work because you're asking for leave. And then if you don't, we'll be applying our policies. And I thought we'd let you know that in 2 weeks, if you're in an unpaid leave, your medical benefits will be cut off the first day of the month following the month in which on the day of the month your unpaid leave begins. So everybody, that's a lot of information, but that's the system. It's effective if you do it consistently, the same way every time with the numerical numbers. It's a date-driven system. How can you discriminate? Because you're treating everybody the same. And both FEMLA and ADA, by the way, require the employee to provide medical confirmation they are eligible for the state and federal protection. And so all HR's job is to make sure they do that. And so we create a very step-by-step system that is date-driven, so we can't indiscriminately discriminate against a protected class person because we are treating everybody the same, even though their mother may die and their doctor just got a heart attack and da-da-da-da-da. I don't care what doctor they go to. I don't care if they go to the emergency room. I don't care if they go to prompt care. My only job is to make sure I have the medical documentation. I'm going to add a little caveat to that. And then I'll talk about ADA specifically. The caveat is, what if they ask you for help? Well, then you're deciding again, what's your standard operating procedure going to be? You could get a HIPAA release and offer to call the doctor's office and say, we can't wait a month. You could lose this employee their job because they don't have protection. We're coaching the employee to understand that should be coming out of their mouth, not ours. But if for some other reason there's a challenge and they need our help, We're becoming counselors now in HR. So if we want to do that, then do it. I can tell you manufacturing companies aren't going to do that. Third-party administrators aren't going to do that. They're going to cut them off. But if you guys want to do that, or your state agency or government agency or county agency, and you're doing that, then you got to do it for everybody. And you're having them sign a HIPAA release, and you're offering to be on the phone with their next medical appointment to explain to the office with the employee on the phone why they could lose the employee their job if they don't sign off on this medical certificate before the doctor gets back in a month. That's the deal. And that's why we use the Venn diagram, because the Venn diagram is my way to explain to the employee whether they have a daughter, sister, uncle, after they've had 14 other jobs, or this is their first one and they're used to high school. This is what we do in our work. These are the policies we follow. And I hear what you're saying. Thank you. But I need to be very clear, but these are our policies. These are our procedures. And we are an incredibly empathetic organization, but we don't change the procedure and the policy and the date, time, and the deadline because you've got a personal experience going on that is more severe and more traumatic than every other one of our employees who needs this help. And that's the hard part of our job. So now we talk about ADA. Now, ADA, when you don't get a medical certificate under ADA, you're protecting them for at least 2 weeks also, even when you transition from FEMLA to ADA, because look at your Venn diagram. These are separate compliance state and federal regulations. They each have their own compliance requirement. Taking care of one does not take care of the other. That's hard for a strong workers' comp scope of control organization to understand. And we're trying to break them of that mold, not be social services and be HR, be paid for our job, know our job, and hopefully somebody will listen to what we're saying. So when FEMLA happens, workers' comp happens at the same time if they're eligible. When ADA happens, workers' comp happens at the same time if they're eligible. When they're pregnant and Pregnancy Workers Fairness Act, workers' comp and ADA happens at the same time, and so does FEMLA. And then you've got these other regulations that are just these high-level pregnancy thing that says, don't mess with pregnant women. So the only thing that protects you is the consistency with which you implement the multiple regulation integration. So when somebody doesn't show up for a medical certificate under FEMLA, they got 15 days, folks. We give them 7 more. Then we transition to ADA and we give them 2 more weeks. That's 5 weeks already. Nobody should get more than 5 weeks to get you a medical certificate, or they should be fired or on inactive status of your workers' comp state. This is a lot of detailed stuff. And it's hard to do in a fast podcast. And that's why we do the 2-day training. And we'll be doing that in September again. But the regulations are very clear. They're different and they don't change. What changes is the way you respond to an individual. And that is the underlying rationale for any good attorney to say that you treated them differently, which means you probably discriminated against their client because they were in a protected class and they didn't get 8 weeks to get a medical certificate before you fired them. So big picture, they don't get you the medical certificate in 2 weeks. We send them a letter. We give them 7 more days. They don't get us a letter in 7 days under FEMLA. We transition them to ADA, inform them appropriately under the FEMLA regulation. They've got 2 weeks to get the certificate, or we'll be cutting off their medical certificate. We've already denied FEMLA, but we have to give them 2 weeks notice if we're going to cut off medical benefits. And then we're going to put them under ADA. If they don't get us an ADA certificate, we're in the 5th week now, everybody. We give them 7 more days, again, because we act in good faith under ADA, which is not FEMLA. It's a different criteria. And then if they still don't show up and get us a medical certificate and we can't engage in an interactive process, they get 3 more days, everybody, and then they're into workers' compensation. And that's when you put them in active status. And Pregnancy Workers Fairness Act changes all of that because it has a different focus on it. But that's the big picture. That is also the confusion. And the real answer is the employee is solely responsible at all times for providing medical certification confirming the need for leave and eligibility under FEMLA at all times. They get 15 days, everybody. Everything after that is a standard operating procedure you create to implement these regulations because nobody tells you how to do it. They just sue you, and they find plenty of attorneys to help them if they don't like the way you treated them. So what we're trying to really focus on is understand an integrated approach and procedure. So there's never a them. Everyone gets treated the same because you have a clear procedure. Doesn't matter whether it's light duty, return to work, modified duty under workers' comp, with FEMLA, without FEMLA, with ADA, without ADA, and or with Pregnancy Workers Fairness Act. It's still the same procedure. And I know it sounds like it can't be true, but it can be. So now, Maddie, ask me the first question again, because there's a second question that is the same issue.
There is a second question, and then there's a third question that was in the chat that also ties into all of this. So I'll read the first
Perfect.
question first and then do that one. So
Okay.
the other one was, we have an employee that requested FEMLA and traveled out of country to care for her father. The employee stated because they were in a different country that does not have FEMLA, the physician would not fill out the paperwork. How do you suggest we handle this in the future?
So I've been dealing with this as long as FEMLA has been around. The first instance that I had of this was a group of employees who worked for a manufacturing organization, and they were all interrelated family members who went to India. And then they'd go to India for a family event and extend it because they had a medical issue. And after a few years, they contacted me and let me know what was going on. They then became a client, and we found everybody a doctor in India. He was a QME, just like we are. We're there. We're all the same humans everywhere, everybody. And then we let the employee know, oh, no, don't worry. We've got a doctor for you to go and see. It only took one employee and 30 more days. And every employee realized if they were going to try and get FEMLA in India, we were going to get a second opinion. It's called curing in a second opinion, everybody. If you don't know it, we train you on it in our stuff. Look it up, ask more questions, but that's what we do. And then the other example of this, and this happened 30 years ago when I was doing the training in San Diego. All of the employees were going to Mexico and getting a medical certificate. And when the employer finally translated every medical certificate from the same doctor, they were veterinarian. So what's the point? You have a standard operating procedure. What's the requirement? The employee is solely responsible at all times for providing a medical certification confirming they are eligible for the FEMLA leave. I don't care if there's a doctor that they can't give it to them. Not my responsibility. You better come back to work. And you know what? It doesn't matter what your organization is. The regulation's pretty clear. What's going to matter is what's your implementation of the regulation. Is that one of those 6-point excuses in the football stadium or the basketball stadium that you're going to let that employee get extra time? Why? Because why? It doesn't matter. It is not your responsibility. We are not counselors. We are HR professionals. When they lose their job and are disabled and go to Health and Human Services around the United States, they can work with a licensed, mastered voc rehab counselor and figure out how to do a job with their disability. But right now, we need them to do theirs here. And if they can't be here, leave is not a benefit. It's a requirement if you're eligible. And the criteria for making yourself eligible is you are solely responsible at all times for providing medical certification confirming you are eligible for FEMLA and need the leave, confirming you have a disability, you're qualified because you can perform the essential functions of the job with this specific assessment, disability aid, restriction taken care of. But it's never light duty. It's never modified duty. This is how my disability impacts my ability to do my job. And if you can't get me that medical certificate, I'm sorry, I'm not able to help you. We don't have a 6-month medical certificate gathering time period. It is 2 weeks under FEMLA, 1 more week to gather it if you can't understand it's required. Then we deny FEMLA because you didn't get us the medical certificate, and we're not required to give it to you because we think you might have it, or we should know we can have it without objective data to confirm it. And then we turn you into ADA. And we really ask you now, how does your disability impact your ability to do your job? We're going to need that by function because light duty is not relevant under ADA. And you need to telecommute doesn't tell us why you can't do your job at the office, and that's what we'll need for that particular issue. And we actually don't do modified, reduced work schedule work and remove essential functions. You need to be here the time you're supposed to be here and do all the functions of the job. So why don't you give us that certification, and then we'll be happy to help you. And if you don't give us that in 2 weeks, we'll give you 1 more week so you really understand. And then if you still don't do that, then we're moving you to all of our other policies and procedures. And that includes union contracts and any state and federal regulations, everybody. And that is the overview of the integrated medical leave and accommodation management system and approach, and what we've been teaching for 30 years. It is big. It has a lot of details to it. But if you're consistent, even with your own culture, even if you want to be more generous, if you want to give them light modified duty for 3 months or 6 months, or let's hope you're not doing it for a year, and you want to be generous when they have workers' comp, but that doesn't mean FEMLA and ADA don't apply concurrently, and you don't have to deal with them. So that was a lot. And we got that all from the one question of what do we do if we go to another country and you say, I can't get you the certificate? And the answer is the employee is solely responsible at all times for providing medical confirmation about why they are eligible for the leave, eligible for the ADA accommodation, and why they need it. And that has never changed. What changes is the way you respond to it. And then you said you had one more question, I think, Maddie.
Yes, it kind of ties into all of this. Anna said, we find physician offices in Arizona are charging upwards of $150 to fill out the initial FEMLA paperwork and then $200 for subsequent follow-up paperwork, which is another obstacle for employees. How would you handle that?
That's not an obstacle. That's a requirement. I think they probably have paid medical benefits. So it is up to the employee to be a jerk with their doctor if they want to. But I can tell everybody, because of the way we're going, my expectation is I bet you have a fund for litigation. You might want to tap into that one and pay $500 to have your employees get a medical certificate so you don't end up in court. That would be my suggestion, everybody. And if somebody really needs help, and the money is the issue, if it's under $1,000, why would we even ask this question? If you're a large corporation, if you're a small corporation that only has 50 employees, if it's under $200, you wouldn't ask that question, because both your CPA and your attorney cost more than that for you to talk to them. Look at the opportunity cost. And then remember, everybody, if you're even at this podcast or you're in this environment, you're an HR professional, and we are done being the administrative assistant. We know more than the CFO, we know more than the CEO, and we know more than the attorney about our jobs if we're doing this at this level. The question is, are they listening to us? Thank you, everybody. I hope that was helpful.